Hi guys, and welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we'll take a part 7 on the law of negotiable instruments, and we'll begin a series on the enforcement of negotiable instruments. Specifically for today, we'll talk about presentment for acceptance as well as notice of dishonor. And for the purposes of presentment for acceptance, we'll also talk about notice of dishonor in case of dishonor for non-acceptance. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, a negotiable instrument can be enforced against the parties primarily liable or, in their default, the parties secondarily liable. Okay? When we talk about parties primarily liable, we have the maker in case of a promissory note, and his liability attaches from the moment that he makes the instrument. When it comes to a bill of exchange, the person primarily liable is the acceptor. In other words, he is a drawee who has accepted the bill of exchange. Okay? And his liability attaches from the moment he accepts the bill. Okay? Now, in case the parties primarily liable do not want, either they refuse or they simply do not pay the instrument, no, then the holder of the instrument can go against the party secondarily liable, like the endorsers or the drawer in case of a bill of exchange, no. However, in order for the party secondarily liable to be liable, no, they must be given notice of dishonor or protest, as the case may be. Okay? Unless, of course, the holder is excused from taking those steps, or if the secondary parties are otherwise discharged. Okay? So let's begin with enforcement, and I want to talk first about a bill of exchange. No? Since we're talking about presentment for acceptance, this will only apply to a bill of exchange, because a bill of exchange must be presented to the drawee in order for the drawee to accept it, okay, in order for his liability to attach. This is not the case in a promissory note where there is no drawee. So there is no presentment for acceptance in case of a promissory note, because again, there is no drawee. Okay? What applies in a promissory note is presentment for payment, not acceptance. Okay? We'll talk about payment in the next, presentment for payment in the next video. Okay? So, when we talk about presentment for acceptance, this is the production of the bill of exchange to the drawee for his acceptance. And as a general rule, presentment for acceptance is not necessary to render any party to the bill liable. Okay? The law gives us the instances when presentment for acceptance is necessary, and the presentment for acceptance is made only in the following cases. First, no, where the bill is payable after sight, or any other case where presentment for acceptance is necessary to fix the maturity of the instrument. Okay? Second, in case the bill of exchange expressly stipulates that it shall be presented for acceptance, no? Of course, that's an express stipulation. And third, where the bill is drawn payable elsewhere than at the residence or the place of business of the drawee. Now, how do we make presentment for acceptance? It should be made by or on behalf of the holder at a reasonable hour on a business day and before the bill is overdue. Okay? It must be done to the drawee or some other person authorized to accept or refuse acceptance on his behalf. Okay? Now, there are certain rules that the law gives us. No? First, where the bill is addressed to two or more drawees who are not partners, okay, then presentment must be made to all of them unless one of them has authority to accept or refuse acceptance for everyone else. In which case, if he has authority, then presentment for acceptance may be made to him only. Okay? Second rule, if the drawee is dead, presentment may be made to his personal representative. Third, when the drawee has been adjudged to be a bankrupt or an insolvent, or has made an assignment for the benefit of his creditors, then presentment may be made to him or his assignee or his trustee. Okay? In all these cases, the holder should present the bill of exchange for acceptance within a reasonable time. And again, what's a reasonable time? We have resort to the instrument, the usage of trade, if any, and the facts of the particular case. Okay? Otherwise, if it's not presented within a reasonable time, the drawer and the endorsers, meaning the party secondarily liable, are discharged and they will no longer be liable. Why? Because they have a right to have the bills accepted immediately. They have a right to have the bills accepted immediately. For what purpose? First, to shorten the time of payment. Second, to put a limit, a limit on the period of their liability. And finally, to protect themselves by other means before it is too late in case the bill is not accepted and paid within the time originally contemplated. Okay? So, after presentment for acceptance by the holder, two things can happen, So, he presents it, and the drawee may either dishonor the bill for non-acceptance, or he can accept the bill. And of course, if the bill is accepted, thereafter, it may be presented for payment, or it may be dishonored for non-payment. Okay? But, let's talk about presentment for payment and dishonor for non-payment in the next video. For now, let's talk about, we're done with presentment for acceptance. Let's go to notice of dishonor. Okay? So, in case again, the bill is presented to the drawee for acceptance, and let's say he refuses, or his acceptance cannot be obtained, then we can treat the bill as dishonored. Okay? And there is a duty now to give notice of dishonor to the party secondarily liable in order to hold them liable. And what is the notice of dishonor? Okay? It is the bringing, whether verbally or in writing, to the knowledge of the drawer or endorser, meaning the party secondarily liable, the bringing to the knowledge of the drawer or endorser of an instrument the fact that a specified instrument, negotiable instrument, upon proper proceedings taken, has not been accepted. Okay? And in case of presentment for payment, has not been paid. But we'll talk about that next time. Okay? And that the party notified is expected to pay. Again, notice of dishonor is the bringing, whether verbally or in writing, to the knowledge of the drawer or endorser the fact that a negotiable instrument, upon proper proceedings taken, has not been accepted, and the party notified is expected to pay. Okay? So, there are three instances of dishonor by non-acceptance. Okay? First, under Section 149, the normal way. When the instrument is presented for acceptance and acceptance is refused or cannot be obtained. In other words, the drawee just says, no, I don't accept, or he doesn't do any act which will accept the instrument. Next, under Section 148, when presentment for acceptance is excused. Okay? And there are certain instances when presentment for acceptance is excused. First, when the drawee is dead, okay, or has absconded, meaning he left, or is a fictitious person, or a person not having capacity to contract through a bill of exchange. Okay? Second case, when presentment for acceptance is excused. Okay? Where after the exercise of reasonable diligence, presentment cannot be made. Okay? Third, where although presentment has been irregular, acceptance has been refused on some other ground than the normal ones that I just mentioned. And the final case, where the final instance of dishonor by non-acceptance is you have to take this by implication when you read Section 150 in relation to Section 136, no? Section 150 requires that acceptance must be made within the prescribed time. And how do we know the prescribed time? We check Section 136, okay? Which it means that the bill of exchange must be accepted within 24 hours. And if not, then it can be treated as dishonored. Okay? So in all cases, Section 150 says that the person presenting the bill must treat the bill of exchange as dishonored by non-acceptance. Okay? Why? If he does not, then he loses the right to go after the drawer and the endorsers. He loses the right to go after the parties secondarily liable. They are now discharged. No, why? Because under Section 151, when a bill is dishonored by non-acceptance, an immediate right of recourse against the drawer and endorsers accrues to the holder and no presentment for payment is necessary. In other words, no? The holder may immediately hold the drawer and endorsers liable for the value of the bill without waiting for the date of maturity. Okay, of course, subject to the giving of notice of dishonor, no, to the drawer and endorsers. Okay, now presentment for payment is no longer necessary. Why? Because payment cannot be expected anymore. Okay, you cannot expect that payment will be made because acceptance by the drawee has already been refused. So there is no point in waiting for the date of maturity to present the bill for payment. Okay? So now the holder can simply demand enforcement of the bill from the parties secondarily liable, namely the drawer and the endorsers. Okay? Now, in all cases of dishonor by non-acceptance, the holder must now give notice of dishonor. Okay? He must give that notice of dishonor to the parties secondarily liable so that he can now enforce the instrument against them and receive payment from them, no? Unless in these cases where notice of dishonor may be dispensed with or excused. Okay? Again, I will now be listing the cases where notice of dishonor is excused, not needed. It may be dispensed with. First, under Section 109, when notice of dishonor is waived. And waiver can be done expressly or impliedly, either before the time of giving the notice or after the omission or failure to give notice. Just take note that if the waiver to notice of dishonor is express and it appears on the body of the instrument, then it binds all of the parties. Okay? Everyone whose signature appears thereon. Okay? But if the waiver appears only above the signature of a certain party, then it will bind him only. Okay? Like it appears over the signature of A, then the waiver will only bind A. Okay? Now, second instance when notice of dishonor may be dispensed with is when after the exercise of reasonable diligence, notice of dishonor cannot be given or it does not reach the party sought to be charged. Now, this is under Section 112. And next is under Section 114, when the notice of dishonor is not required to be given to the drawer. Take note, this is the difference between 114 and 115. In 114, notice of dishonor is not required to be given to the drawer as stated by law, but in 115, it involves the endorser. Okay, so let's take up 114 first, no? Notice of dishonor is not required to be given to the drawer in the following cases. First, no, where the drawer and the drawee are the same person. So it's pointless. It's the same person. Okay? So you don't have to give notice of dishonor to the drawer. Second, when the drawee is a fictitious person or a person not having capacity to contract. Again, it will be useless. Third, when the drawer is the person to whom the instrument is presented for payment. Okay? Fourth, when the drawer has no right to expect or require that the drawee or acceptor will honor the instrument. Okay? And last, no, where the drawer has countermanded payment. Okay? Now, when we go to section 115, this is the case where notice of dishonor is dispensed with or excused because a party, this party knows about the dishonor, no? He has knowledge. He is charged with knowledge, no, whether actual or constructive, no? Okay, so section 115 gives us the cases when notice is not required to be given to an endorser. Okay? So first, where the drawee is a fictitious person or a person not having capacity to contract, and the endorser was aware of that fact at the time he endorsed the instrument. Again, he doesn't have to be given notice of dishonor because he knows that the drawee is fictitious or doesn't have capacity. Remember, I mentioned earlier that if the drawee is fictitious, the notice of dishonor will be useless. And if the endorser knows this, so you don't have to give notice of dishonor anymore. Okay? Second, where the endorser is the person to whom the instrument is presented for payment. And third, where the instrument was made or accepted for the accommodation of the endorser. Why? Because he's the party ultimately. He's liable for that accommodation, no? Okay? And the final case when notice of dishonor is excused or not, or maybe dispensed with, is in case the holder failed to give notice of dishonor and the instrument is now in the hands of a subsequent holder in due course with no notice of the failure to give that notice of dishonor. Okay? Why? Because the rights of a holder in due course are not prejudiced by the failure of the previous party to give notice of dishonor. Okay? In other words, if a party who is entitled to give notice of dishonor fails to give such notice of dishonor and then later on the bill is subsequently negotiated to a holder in due course, Section 117 says that the holder in due course is not prejudiced by the failure to give notice of dishonor by the prior party. Okay? In other words, the holder in due course may still present the bill to the drawee for acceptance, and in case of refusal, he can still give notice of dishonor to the party secondarily liable. Okay? That's in case of a subsequent holder in due course. Okay? Now, dishonor may be oral or written, and it must be given by the holder or his agent, and you must give it to thus the party secondarily liable or his agent. Okay? Notice of dishonor must also be given within the periods provided by law, no? And these are contained in sections 103, 104, and 107, no? You can look them up, no? But I'll give you an idea, no? So in case of the parties live in the same area of residence, no? Then of course, before the close of business hours on the following day, or before the usual hours of rest of the following day, or if by mail, then it should be sent in time to reach the addressee in the usual course of the following day. And in case the parties reside in different places, if by mail, it must be ready to be delivered by the following day, or it must be sent within such time that the notice would have been received by the addressee in due course of the mail, meaning by the ordinary processes, no? Now, notice of dishonor must also be given at the proper place. Okay, so if an address was written on the instrument, then it must be given there. Okay, or the notice of dishonor can be given at the post office, which is closest to the residence or place of business of the addressee. Okay, or it can be given either at the place of business itself or at the residence of the addressee, or it may even be given in the place where the party is, where the addressee is sojourning. Okay, and the notice of dishonor, however, it must contain the following items. First, okay, there should be a sufficient description of the instrument, the negotiable instrument, to identify it. Okay? Second, there should be a statement that the instrument has been presented and that it has been dishonored. And finally, there should be a statement that the party giving notice intends to look for the party addressed for payment. Okay? In other words, hey you, please pay this now. Okay? I'm holding you liable on this. Okay? So, the notice of dishonor, just remember, no, it must be given to the party secondarily liable, otherwise they will be discharged. Okay? So now, in case the notice of dishonor is now given to the party secondarily liable, to whose benefit does the notice of dishonor inure, no? For whose benefit is it? First, in case the notice of dishonor is given by or on behalf of the holder, then all parties prior to the holder who have a right of recourse against the party to whom the notice is given, they benefit from that. And second, in that case, no, all holders subsequent to the holder giving notice. Okay? And second case, in case the notice of dishonor is given by or on behalf of a party entitled to be given notice, then the parties who benefit would be the holder, and second, all parties subsequent to the party to whom notice is given. Okay? Now, just a few final pointers. Under section 113, delay in giving notice is excused, no, when caused by circumstances beyond the control of the holder and not imputable to his default. Take note, this section 113 is different from the absolute cases of that I mentioned earlier, when notice of dishonor may be dispensed with or excused. Because in the cases earlier that I mentioned, no, like a waiver or when it's not required to be given to the drawer, etc., no, in those cases, what happens is it's now those secondary parties may now be held liable right away without the notice of dishonor anymore because it's excused. But what is excused under section 113, the one I'm talking about now, is merely the delay in giving notice of dishonor. Okay, it's the delay that is excused, meaning that I'm supposed to give the notice of dishonor now, no? But I am not able to because there are circumstances that are beyond my control and not imputable to my fault, okay? To my default, my misconduct, or negligence. Let's say an earthquake, okay? And that's why I'm late in giving the notice of dishonor, okay? Now, what is excused is the delay, and I keep emphasizing that because under section 113, it says that when the cause of the delay has ceased, you still have to give the notice of dishonor to the party secondarily liable. Okay? So, it must be given with reasonable diligence. Okay? Now, finally, if an instrument is not accepted by the drawee, then there is no sense in presenting it again for payment. Okay? So, notice of dishonor should be given at once to parties secondarily liable. Otherwise, they shall be discharged. Okay? But if there was acceptance, instead of the drawee saying, no, I refuse, or he's not doing anything, no? In case he says, okay, I accept, and then he stamps the word accepted, or he writes accepted, or in any other manner, no? If there was acceptance, then the next step now is presentment for payment. This is a bill of exchange, remember, there's no presentment for acceptance in promissory notes. Okay? So, in case the bill of exchange was presented for acceptance, then it is accepted, then the next step is to present it for payment, no? Because it may be due on another date. Remember, one of the cases is when presentment for acceptance is necessary is to set the date of maturity. So, I present it for acceptance to set the date of 30 days from acceptance, kunyari, no? So, I go back again after 30 days and I now present it for payment. Okay? Now, when it comes to payment, there are two, it branches into two steps again. It can either be accepted, and if paid, then it will be discharged, no? Then the instrument will be discharged. But if it is dishonored, then the holder must now give notice of dishonor Okay? Notice of dishonor for non-payment. Earlier, we were talking about dishonor for non-acceptance. Now, if the instrument is presented for payment and it has not been paid, then in order to run after the secondary parties, the party secondarily liable, then the holder must now give them notice of dishonor for non-payment. If he does not give them that notice of dishonor for non-payment, then they will be discharged. Okay? We'll talk about that more in the next video. I'll talk about presentment for payment, and of course, I'll review a little bit about notice of dishonor, and hopefully we can also go to discharge. Okay? So that's it for presentment for acceptance and notice of dishonor. I hope you may have picked up a thing or two, and I hope to see you next time in my next video. No? See you soon. Bye.